today, President Trump spoke to members of law enforcement in Washington, where he ripped into a federal appeals court after its judges pushed back on government arguments to lift a temporary halt on the White House travel ban. Mind you, they haven't come to a decision yet. Here's Mr. Trump.
Right now, we are at risk because of what happened. I think it's a sad day. I think our security is at risk today, and it will be at risk until such time as we are entitled and get what we are entitled to as citizens of this country. They're taking away our weapons one by one. That's what they're doing. And you know it, and I know it, and you people have been very unhappy for a long period of time. This is a weapon that you need, and they're trying to take it away from you, maybe because of politics or maybe because of political views. We can't let that happen.
President today also attacked the courts as so political, unquote, and suggested their actions might be biased against him. And then he tweeted a warning that, quote, our people are far more vulnerable right now, presumably a reference to the court case. Now, these statements are the latest in a string of comments that seem to stoke fear about the court's actions we don't know yet. Here's President Trump yesterday at the White House.
This is a very dangerous period of time because while everybody's talking and dealing, a lot of bad people are thinking about, hey, let's go in right now. I actually can't believe that we're having to fight to protect the security in a court system, to protect the security of our nation. I can't even believe it. And a lot of people agree with us, believe me.
And here's what the president tweeted after a federal judge initially halted the travel ban late last week. Quote, just cannot believe a judge would put our country in such peril. If something happens, blame him and court system. People pouring in bad. Folks, the administration's Homeland Security chief testified to Congress yesterday that this executive order should have been delayed. The president's attack on the judicial branch is another example, whether intended or not, of an attack on an American institution like the press, Congress, the integrity of the election, the intelligence community, and so on, that the unintended consequence, or maybe it's the intended consequence, is to undermine the legitimacy of the judiciary, if that is what the goal is. I'm joined now by Stan Brand, who is the general counsel to the U.S. House of Representatives, now a lawyer with Aiken Gump, specializing in the separation of powers doctrine. And Jonathan Adler is a professor of constitutional law at Case Western University, a contributor to the Washington Post legal blog, and a former appeals court clerk. So, gentlemen, I want to get both to what the president's comments about the judiciary and what we heard from Judge Neil Gorsuch, but then also the case itself. So I want to split the conversation in half. So, mind you, you'll have time to talk about the case itself. So, Stan, let me start with you. Are the president's comments, do you think they crossed a line when it comes to the head of the executive branch chastising the judiciary?
Our federal judges aren't wilting violets. They've come up in the litigation system. That's why the framers gave them life tenure, and you can't reduce their compensation during their term. Look, these separation of powers questions over nerve center questions draw a lot of heat. When President Truman seized the steel mills, he was very upset when the court overruled him. Mm-hmm. When the Supreme Court overruled the House of Representatives' exclusion of Adam Clayton Powell, members took to the floor to offer impeachment resolutions. This is the nature of separation of powers. And what really matters is not what he says about the judges, but what he says and what he does ultimately if there is a ruling. That is where push comes to shove.
Professor Adler, let me play one more soundbite from President Trump today about the idea that courts are biased, and I want to get you to essentially respond to the same question. Here it is.
I don't ever want to call a court biased, so I won't call it biased. And we haven't had a decision yet. But courts seem to be so political, and it would be so great for our justice system if they would be able to read a statement and do what's right. And that has to do with the security of our country, which is so important.
All right. Again, Professor Adler, before we get to the substance, there's working the refs, and then there seems to be almost getting to a position where the refs feel as if they're in a no-win situation. Where are you on this?
Exactly, and we're getting to the latter. I mean, those sorts of comments about a pending case are not responsible, and I don't think they're helpful either. It's one thing to criticize the substance of a court's opinion. It's another thing to go after the judges and to question the legitimacy of the court's decision-making process. And the president's been doing the latter. We saw with George Bush that one can express disagreement with judicial decisions about very important questions relating to national security without questioning the legitimacy of the courts and without putting the judges in a position where they might feel they have to demonstrate their independence, which can only compromise their decision-making.
Yeah, I was just going to say, Stan, I mean, how concerned are you about this issue that, yes, we know judges they made it that far because there was a belief that they could sort of tune out the political noise. But, you know, it can't be easy in this day and age. Well,
Again, they're given certain protections. They're given lifetime tenure. They're given, unchallengeable pay. They are separately regulated themselves through their own processes. So, again, I understand this is sharp rhetoric. It's before the court has even ruled. I just don't think it's going to affect the outcome. I don't think there's a federal judge sitting on the bench who's going to be influenced by this kind of talk.
But shouldn't we be concerned, Professor Adler, about how the public, views it? Because he's basically sent a signal that says, if he doesn't agree with the decision, then you know what? His people shouldn't agree with the decision.
I think that's right. I mean, I think calling into question the legitimacy of a judicial ruling and calling into question the legitimacy of a ruling that hasn't even come out yet is very problematic. I mean, at the local level, we recognize this without question. A prosecutor, a local DA, can't comment publicly about a pending case beyond saying what he's doing. Certainly can't talk about what a responsible or law and order judge would do in a case. We recognize that that's inappropriate, and in a lot of cases, that could even subject the prosecutor to sanctions. The president is essentially doing that same sort of thing, but at a national level. And whatever the merits of the underlying legal arguments, that's just not the sort of thing the president should be doing when we're talking about a case that's still pending in the courts.
All right, now let's get to the substance of the argument. We had the president reading the statute out loud, and I'll just read part of it, but he believes this gives him wide powers on this, and he's reading 8 U.S. Code 1182. Whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may by proclamation and for such period as he shall deem necessary suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Is he right here, Stan Brand, that essentially this sort of supersedes everything else?
Well, he may get deference and he may get priority, but I don't know that that statute withdraws judicial review over his actions. That's been something presidents have asserted from the beginning of time. Richard Nixon asserted that the court had no jurisdiction to decide the tapes case. This is something that has, from the beginning of the Republic, been the province of the courts, and that is to say what the law is. That doesn't mean they won't defer. That doesn't mean he has very broad discretion. And from the questions that I heard asked yesterday in the oral argument, the court had some pretty important questions about the factual basis for that finding. And so I think there's room for judicial oversight even of these types of very sensitive questions.
Professor Adler, your take?
Yeah, I think the president's legal case is quite strong. I mean, the existing precedent establishes that the executive branch and the federal government generally have very broad discretion in the immigration context. Congress has given the executive branch and the president in particular exceedingly broad discretion. This is not a case like where you have an agency action that has to comply with the Administrative Procedure Act. This authority is given to the president himself, who's not bound by the Administrative Procedure Act, and Congress has not put any constraints on the way that discretion is exercised. So I think the president's legal case is quite strong, and if I were advising him, I would say let the lawyers speak. Don't make these out-of-court comments. Let the briefs speak for themselves.
Professor Adler, there are a lot of people that have been in and out of Trump Tower that have believed that they could provide that kind of advice and not always have it taken. Anyway, Stan Brand, Jonathan Adler, thank you.